Okay, thanks for joining. This evening is January 30th, and I'm just going to make this a recorded video so that I don't do the call live this evening. I'm sorry for that, and you have to look at my ugly mug here for the call if you want to listen to it. So I hope you'll find this beneficial. It is material I've covered before, but I wanted to go into more detail. And I'm going to show you my notes here, right? So we'll get to that in just a second. Remember, we have aceofcoins.club that has the complete video series and all these different subjects. Aceofcoins.com is a way to schedule interviews with me, or you can do interviews or consultations. And if you wanted to get the consulting package, that's mostly what people do at aceofcoins.com. You can register for that. And then we have the other promotional sites. These are two sites that I want to really focus on this year, and you're welcome to promote them. If you want to work out a special arrangement with me, we can do that. That is divorceandestate.com, and also cryptosarenot taxable.com. Okay. But the core site is aceofcoins.club and aceofcoins.com. So for this evening, I just wanted to cover the aspects of a petition for the declaration or dissolution of marriage. Okay. And I know we've talked about this before, but I wanted to get into some more detail. Last week, I believe we covered pleading practice, okay? And I went into a little bit of this, but I want to go over the items. So let me just give you a general idea of what I'm talking about here. So typically in a divorce proceeding, someone files a petition for divorce. And I'm just going to talk from the stereotypical example of the wife who leaves the household and then files for divorce with the court, okay? So she becomes the plaintiff, petitioner, whichever is all the same. But she becomes the plaintiff and the husband becomes the defendant. And then typically what she's asking for is the declaration of the dissolution of the marriage, which is pretty easy to do because all the husband has to do is agree and file a notice that the marriage is dissolved, and it's pretty simple. And then the judge should agree and sign his order dismissing the case or whatever, and that's the end of it. But that's just not what's happening. What's happening is the court is being used to liquidate the husband's property. Okay, stereotypically. Now I know that's not always the case, but the wife is leaving with nothing, with no resources, without terms. She's leaving the household, and then she's coming back in to intrude upon the family, the household, under new terms that were never agreed upon. Okay, so think about it like this. So you have the husband and wife, and let's say two children. And the husband is taking care of the family. He's got a job and he's paying the bills, and the wife is taking care of the household and take care of the children. And the children go to school, and that's your typical stereotype. I know that's not always the case, but let's just start from this example, all right? So then someday the wife decides that she's going to want to divorce the man for some reason. Okay, doesn't matter. So she calls up her sister or something and goes to her sister's house, and or however she works it out, and leaves the household. Well, keep in mind that she was the owner and still is actually the beneficial interested party, the beneficial party of all the comforts, the conveniences, the property, the chattels. When I say chattels, I mean the things in the household. Okay, she was the beneficiary of all those things. In fact, she has an ownership interest. Can we ever discover what that ownership interest or the percentage is? Not really. Can we say that it's fair if we just split them up 50-50? That sounds kind of arbitrary. And in fact, it is, because that is not how things work, okay? The Let's say the husband makes all the money, and it's divided up to take care of the family. It pays the bills and all these things. Sometimes the wife has a job also, and her money sometimes goes into the household. How do you figure out whose percent is what? It never was like that, okay? So it can't become like that. It was never like that. So the wife that left the household that wants a divorce left without terms. That's almost always the case. She leaves without terms. What were the terms before? Well, the terms before was that she could enjoy the benefits of the household and get enjoy everyone's the same thing that everyone else does, right? But she left the household. So not only can she not enjoy those because they're not within her reach, so to speak, but the husband can no longer protect her and take care of her because she left the household. She left his care. She left his home, his ability to provide all these things. So she's changed the manner in which he can provide the care that he was, and she's abandoned her conveniences and property rights and everything of that nature. Now, I wouldn't say property rights, however, there was an arrangement, okay, while she was there that served everybody, and she's altered that arrangement unilaterally. It's not for the man to accommodate her, it's not for the husband to accommodate her. So understand that she's left the household without terms, whether or not there's a postnuptial agreement or prenuptial. Okay, if there's a postnuptial or prenuptial agreement, if there's written terms about the event of divorce, that's different, and we'll get into that shortly here. But most of the time she leaves without terms. It's so important. I'm going to say this again. She leaves without terms because then she goes back into the court and she asks the court for the dissolution of a marriage. And then the attorney, in most cases, the attorney that proceeds into asking financial questions of the husband for the purpose of dividing up his property. Yet in the petition, now remember, the court can only take jurisdiction over what is alleged as long as the court does have actually subject matter jurisdiction over what is alleged. If there's something that's not alleged, even if the court has subject matter jurisdiction over it, it will never obtain personal jurisdiction or the ability to act upon allegations that are not in the pleading, is what I'm talking about, okay? You can call it in personam jurisdiction or personal jurisdiction. What I'm talking about is the court does not have jurisdiction to take actions for things that are not alleged in the pleading. So if the pleading is alleging the dissolution of a marriage and wants only declaratory relief, and maybe it checks some boxes for custody and things of that nature, there's some problems with that because it's not specific enough and it's not alleging obligations to pay child support. It's not having obligations regarding the payment of money to the wife after she leaves the household. There is no such obligation unless it's in a postnuptial or prenuptial agreement, okay? So furthermore, the petition, okay, which is assigned a case number and then the attorney gets involved and he gets all the discovery, if it fails to include an allegation that there's a duty to pay money to the wife upon a certain thing happening, like when she leaves, well then conducting discovery about your finances is not permitted because the court doesn't have the authority to engage in that. The court can't make you talk about your money because there was no issue of a debt obligation in the pleading. Now, some attorneys will say, but this statute says that we can divide up the property. Okay, well, the statute does not create a debt obligation. Again, even if you could divide up the property, that would be where the court actually has jurisdiction. Like it's within the purview of the court. If you're just asking the court for a dissolution of marriage, it's not within the court's purview to investigate your financial matters so it can then tell you what to do with your money. Remember, you're the one that decides what to do with your money because you're the boss, right? You have the liability. No one can tell you what to do with your money. So unless you've decided ahead of time, you've agreed ahead of time in writing that something you were committing to do something different with your money other than what you were doing to serve the household, then okay, fine. Unless you've done that, you can't be held to that. No one can cite a statute that says this statute says we get to split up your property. That doesn't apply to you. Okay, it only applies where the court has a duty to act, and we'll get into that in just a second here. So this is so important to understand. So the pleading is, like I explained last week, is so vital to establishing what the court is allowed to do. But you know, the attorneys ignore that. They start citing all these extraneous things like the statutes and the rules and it's fair and all this stuff, and that has nothing to do with what was in the pleading. Okay, the allegations are what allow the court to act. And so if the court has a jurisdiction to do a thing and it's alleged properly in the pleading, well then it creates a duty to act. Now, whatever is being alleged in the pleadings, in any case actually, the court does have an underlying duty. That's the whole basis of our court system, okay? The underlying duty of the court is to preserve the status quo, preserve what has already been before we got to this moment, okay? So how do you preserve the status quo? You have to first know what the status quo is, right? So how would you know that if you're the judge? What is the status quo? You know, important things like, for example, uh, how money was allocated, right, in your family, how to take care of your family, things of this nature, okay? Uh, who was responsible for buying new shoes for the children, you know, things like that. Taking them to soccer practice, making sure they went to the doctor on time, uh, things of this, excuse me, things of this nature, okay? These constitute the status quo. Well, these things are never alleged in the divorce petition. No attorney is even competent. They don't even think of these things, okay? The court has a duty to preserve the status quo, but is unable to do so if the status quo or the elements of the status quo are not alleged, which might take a page of allegations, maybe 2 pages of allegations, enough to get the judge involved, you know. Now, the judge still can't get involved in the way the family was operating, okay, the way it was allocating money, unless there are, with the status quo allegations, there are also allegations of abuse, neglect, or imminent harm. Okay, there have to be allegations of abuse, neglect, or imminent harm, which would give the court a duty to act. Now, what would the court do? The court would seek to try to cure or prevent the abuse, neglect, or imminent harm, right? And the way it would do so would be to force things like order things to be done with the property. Or maybe it would order an injunctive relief against the husband. You can't come on here, you can't go over there. There might be these things, and the court has complete jurisdiction to do these things, okay? But without allegations that there is abuse, neglect, or imminent harm, and without allegations saying how these things could be cured by obtaining financial information, the court cannot get involved. It's so important. There's no duty to act. So let me just go here and I'm going to show you my notes. These are so important. This language is going to help you, okay, if you're in that situation. Let's see here. All right. So here are the notes for this part. Now anyways, I'm going to do this today, and then I'm going to follow this up with something else we can do. Now, I guess the whole point of this presentation is I want to show you how the court is falsifying records and setting up a situation where the state can make a false claim to the United States government and obtain money. But before we get there, I just want you to understand really closely how this all plays out. So you just understand the pleading aspects and what's necessary, right? And what the court's duty is, right? And when the court can act. So let's go into some of these things here. This should start making sense. And I know this sounds a little bit somewhat scholastic. I'm not trying to do that. This is my writing voice, but it has to be that way. But as you can see, we want to move the court to dismiss. So let's say the petition gets filed, right? So based on what I just told you, there should be, you should have it dismissed if you agree to the divorce, right? You file the dissolution notice. They're not expecting that. Nobody does that. But you file it and you say that the case should be dismissed because there's nothing more to do besides announce the dissolution, right? Because the pleading doesn't identify or express any justiciable controversy. There's nothing here for the court to deal with. There's no controversy anymore. The court can only deal with controversies, adversarial parties, okay? Adversaries. That's why they call the husband and the wife plaintiff and defendant. It shouldn't be titled that way. The caption of the pleading should read something like in the marriage of, okay? It should not be naming the husband and wife as plaintiff and defendant, but this is how the court operates where there's an adversarial situation and there's not in a marriage. But they're trying to create a case so they can function. This whole system can function so they can liquidate you. But anyways, so you want a dismissal when there's no duty to act, right? So once you've agreed to the dissolution, then there's no further duty for the court to do anything, right? The court doesn't have a legal duty, therefore it doesn't have a legal authority other than dismissing the complaint, right? So let's go into the pleading. This is very important. So the pleading normally fails to allege or describe any marital community or marital state. And this is the object of the pleading, is what the court wants to do, the attorneys want to do, is break up the marital state, right? Under arbitrary terms that don't even relate to the intelligence that you've utilized to take care of your family, how you're going to pay the bills, right? That's a very complex arrangement that it's nobody's business. Who are they to come in and say, let's split it up, right? So the way we address that is we talk about the fact that the pleading fails to allege or describe the thing that they want to break up, the marital community, the marital estate. Okay, so just for the sake of this conversation, the marital estate is the property that makes the family household work well. That would include all the appliances, the furniture, all right, anything that provides comfort and convenience for the members of the family in the household, in the single household. Okay, that's how we live, in a single household. All the property. Then we get into things like the jewelry, the electronics, the vehicles, right? Things that make things work. That's the marital estate. The marital community, it says here, no marital community, estate, or collection of property or property rights is named as a party to the complaint. And I use the terms collection of property rights. All right, that would be part of the estate as well. We'll get into that we'll get into more detail. I don't want to go too far on this call, but the pleading fails to allege property or chattels within the marital community. So for example, it fails to allege the existence of cookware in the kitchen, simple things, furniture, right? Specific furniture. Now, it could. The pleading could do that, but most don't. The pleading fails to allege the name and address of the trustee for any property. So who's to say that all the property in your household isn't held in trust by a trustee who's allowing you to use the property? Now, that's going to open a can of worms. I'm not going to get into that right now. That's something that I provide for clients. We can talk about that. But right now, just take it at face value, if you will. Right? The pleading is not served upon any trustee or trust, and the trustee is not named as a party. So you can't attack the marital community if you haven't served the trustee who owns the marital property. That throws them through a big fat loop. They don't know what to do. They know what that is, but they never expected that, okay? You can use this as a strategy. I can show you. The pleading was not served upon any trustee. That's right. So the pleading fails to allege any liens or claims upon any property or chattels within the marital community. So not only did you not allege or describe the existence of the marital community, you didn't allege that there were claims against it. So how can you talk about splitting it up under certain terms when there are no terms either? It's not there, right? There are no terms. So how can you talk about that? It didn't describe any aspect of the marital estate to be collateral, okay, for any claims of debt. All right. There are no perfected security interests. The pleading fails to allege the existence of any underlying debt, including but not limited to previous application of any debt. The previous adjudication of a debt. So the way it would look is the petition for dissolution would include allegations of a debt that's been previously adjudicated, and then you would be asking the court to impose a levy process, right, that allow you to recover the money that was already adjudicated, the debt claim. Well, none of that's alleged in the complaint, and of course, the adjudication of a debt obligation doesn't exist. Like, for example, there's no debt obligation that the husband has to pay the wife anything. Now, I know this is kind of like mind-blowing, makes you think for a second, because we've been programmed to believe that just because there's a divorce, there's alimony and child support following that. It's not. It's not supposed to be that way. All right. So the pleading fails to allege any duty for the defendant to pay or give. And we can word this however, but I'm just putting this here. Notice how I have this in red font, so I'm not finished with editing this the way I want. So let's go. The pleading fails to allege any entitlement or expectation for the petitioner, usually the wife, all right, to receive money or other property from the respondent, from the defendant, the husband. The pleading fails to allege any prenuptial or postnuptial agreements that create any obligation or duty upon either plaintiff or defendant of any kind, including but not limited to the liquidation, sale, or distribution of property or income. All right, so we're in cases right now where the attorney's saying, you are subject to the jurisdiction of this court, and the court can split up your property. And you don't have a postnuptial agreement that prevents that from happening. And so my response is, you don't have a postnuptial agreement that allows you to do these things, and statutes do not create debt obligations. Now you're naked. You don't have an argument, right? You see how this works? The pleading fails to allege any prenuptial or postnuptial agreement. This is so important. Because these creatures operate by written words. You have to go by that, okay? So no written claims, complaints, or allegations served upon any party satisfying the criteria for service of process against the marital estate or any property within either have been made. Okay, there's been no written claims against the marital estate, no service of process for claims. So there's no jurisdiction, okay? If there's no service of process, there's no jurisdiction. That's what I'm trying to say here by this statement. I know it sounds cryptic. The pleading names Mr. and Mrs. whoever and as plaintiff and defendant, however, it fails to allege any genuine or material facts that would otherwise establish, excuse me, that these two have adverse interests, or any set of facts that would demonstrate any diverse adversarial interest over property or property rights. In other words, why are we even in court? We're not adversarial parties. There's no controversy. Okay, especially when the wife left without terms. Back to that again, right? The pleading fails to allege, and I should say pleading, not pleadings, but the pleading fails to allege any chattels or property or debt obligations regarding the property or property rights of, or any estate. Now, property rights do include child custody. We'll get into that later. So it sounds redundant. If you look carefully, it's not redundant. I just don't want to miss anything here. The court has a legal duty to preserve the status quo. We know that. And the court does not have a duty to do anything else unless it means preserving the status quo or preventing or curing abuse, neglect, or imminent harm, which preserves the status quo, doesn't it? It all comes back to this. Each have the right, each of them, husband and wife, have the right to rely upon the court's duty to preserve the status quo. The court is unable to preserve the status quo for the reason that it cannot consider the balance of the equities because the pleading fails to describe or allege any facts or aspects of the status quo regarding the husband or wife and their property rights, or the manner in which they care for their children. How can the court preserve the status quo if the elements of the status quo have not been alleged? Not possible. The court has an undisclosed, now we get into this, the court has an undisclosed financial interest in the proceeding. The court has an undisclosed conflict of interest in the proceeding. And we're going to get more into this. I already talked about this on some of the other calls, but I think for this call, I'm just going to get into this aspect of showing you why I'm not a crazy person, okay? What the aspects of jurisdiction are to be, and how we articulate these and how we proceed forward. So the way you proceed forward is when you receive a petition for dissolution of marriage, okay, in the stereotypical example, you would move to dismiss and also file a notice that you agree, okay? That would be grounds for the dismissal, right? The way they have a problem with that is everybody, the judges and the lawyers are so used to liquidating you that they can't understand that, it's over. So you got to be careful there. So the state is involved in the scheme, and then we get into how the state is being compensated from the United States government, right? So absent allegations of abuse, neglect, or imminent harm, child custody and other marital and postmarital associations are private and intimate. Think about it. Private and intimate. You can't intrude upon these things, all right? Unless there's some due cause, there has to be good cause. Beyond the scope and purview of the pleadings. So at the very minimum, if you've not alleged, again, abuse or something, or neglect or imminent harm, then it's beyond the scope of the pleadings and the court's jurisdiction to get involved with more than just declaring the dissolution of the marriage, right? The court has no legal duty to thereby, and thereby no legal authority to intrude upon the private and intimate affairs of the parents or the husband or wife, whether now or following the dissolution of their marriage, for the reason that the court is not responsible for the care of the people benefiting from how the husband and wife have organized their affairs and choices they have made regarding the allocation of their resources in the fulfillment of their obligation to family members. The court has no such obligations, right? The husband and wife have those obligations exclusively. The court has no legal duty to, or thereby legal authority. So if it doesn't have the duty, it doesn't have the authority, right? To use public funds for the purpose of indemnifying the husband and wife for hardships or losses incurred by intruding upon or interfering with the manner in which each has chosen to allocate his resources for the benefit of themselves, right? Pedantic about that. So the court doesn't have the authority. So here's an interesting situation. Let's say the court says you got to sell your house to the husband, you got to sell your house and split the equity with the wife. Well, if I sell my house, judge, it'll cause a financial hardship. I don't care. You have to do it. That's not what the court is for. Okay. The court's not supposed to be there for that purpose. All right. So the court cannot be used to amend or modify agreements, okay, because it was not involved in collecting and analyzing the reasons behind forming such agreements. Well, because really, so the court is not involved with analyzing or the reasons behind forming the agreements, and intruding upon agreements is careless and it will destroy the status quo that was intelligently created by the agreement. And the agreement does not have to be in writing, by the way. It's not for anyone's review, okay? It's only for the use of the parents and the husband and wife, all right? So the court cannot be used to change agreements. This is so important. The court does not have the jurisdiction to change agreements. That's not what courts are for. They're supposed to resolve disputes within agreements, okay? Now, the parties can the parties can change the agreements themselves. It's known as a settlement, and the judge can make a determination that that's a valid, acceptable settlement agreement. That can happen. Statutes, likewise, do not create such obligations like financial obligations. Statutes don't do that. Rules of procedure don't do that. There has to be existing underlying obligations for which the court can adjudicate. They're not to be created by statute, because imagine if you could have a statute that created a financial obligation. All they have to do is file a lawsuit and make money. That's ridiculous, right? These agreements, such as those arrangements between the husband and wife and mother and father, are private, intimate, and while the court admits and acknowledges that such agreements exist, it has to. No provision of such agreement is subject to the scrutiny by outsiders, and there is no burden to prove any term or provision of the agreement. That's what I'm telling you. You don't need to have it in writing, okay? Now, this is where I get into the wife abandoned the marital home. Okay, she thereby abandoned her related benefits, and she did so without terms. She cannot now use the court to impose new terms for her benefit. She cannot now use the court to countermand Mr. Smith's authority. That's what she's trying to do. She's trying to countermand the husband's authority. She cannot now use the court to countermand his authority because only the husband has the fiduciary obligation to his family. And it doesn't matter if the wife makes more money, but in my stereotypical example, we're saying the husband makes all the money, okay? The husband has a fiduciary obligation to his family, and the court has no fiduciary obligation to any member of his family. Liability confers authority, and the court has neither. The court is not liable for the care of the children or the care of the household or the care of the wife, whether or not she's left the household. That's for the man to decide. That's for the husband to decide, okay? Those are my notes on that aspect of it. So what I'm trying to make the point of here is that the divorce petition, okay, excludes so many allegations, necessary allegations, then the court proceeds as if those allegations existed, as if the court made the allegations itself, okay, and then proceeds to enter a judgment, like there's a judgment of a resolution of a dispute, when really what the court's doing is intruding upon the family and pillaging the marital estate. And then once those orders come in, namely the child support and alimony court orders, okay, once those come in, the case file can then be monetized. I'm not using that word correctly, but just say can be used to apply to the United States government for matching funds. It's a matching fund scheme under the Social Security Act, okay, as I mentioned before. And so the adjudication, okay, that the judgment made in the case is based upon nothing. There is no debt obligation that was adjudicated. They just made up a bunch of obligations that didn't. There's no supporting the debt. Okay, there's no supporting obligation. But the court said you're going to pay this and you're going to pay that. But that's not the purpose of the court. It was without jurisdiction, first of all, and there were no supporting facts. So that's why the claim is false. It's a false claim. That's what's happening here. So let me conclude with that, and I hope this is helpful to you. I'm going to be live next week. I'm sorry I didn't make it this week, but I will continue this. I want to get into the False Claims Act, okay? And this is the important understanding, this part of it. So I hope you enjoy these two videos, and see you next week.